Hi, I'm Danette Grau Kohrs. I am the founder and managing partner of Trinity Strategic Growth Solutions and the co-developer of a program called Build It to Grow. I'm also a growthologist, which basically means I am passionate about and I love studying the science of business growth. So be sure to stick around to the end of this video because I'm going to share with you some of the free business growth tools that we make available and tell you how you can take advantage of those.
Do a quick introduction. Eric Westacott is here, joined the call today. Wanted to do a presentation on managing liabilities during entrepreneurship during a pandemic, and particularly a little bit around employees. Eric is Build It to Grow alumni that finished our Build It to Grow program a couple of years ago and participated in that for a company that he was a founder of that manufactured devices for individuals who are trying to develop strength in their body. And I won't go too much into that right now, but he's also a business attorney. And so I invited him to come speak on looking at liability during a pandemic, because as we've talked about before, there's no books on this. This is brand new to the entire world, really. And so a lot of questions are out there. So Eric was kind enough to put together kind of a little bit of an overview and then to make it interactive. So we're going to kind of record it now and then essentially work this through again with everyone where you may have some direct questions that you want to bounce by him. So with that being said, Eric, is there anything you'd add to kind of my intro on that?
Yeah, I thank you, first of all, for letting me participate. And then second, when I actually sat down to build the presentation, I realized that it would probably be more effective if we had sort of a broad brush kind of approach to all things COVID for what folks are experiencing out there in the business environment. So I wanted to kind of give it a little bit more of a generalized focus. And then that way, if we do get an opportunity to do an interactive, then we can drill down on some of those issues that are more important because there just are so many. And as you eloquently said, everything is changing every day. So a question today may not be a question tomorrow, and we just don't know what we don't know today. So I thought I'd build it that way.
Not a problem.
All right. And really, as by way of introduction, you really did a fine job for me there. But I thought in preparing here, what we'd look at were sort of three separate areas that I think most business owners are going to be looking for answers with regard to COVID. And I generally put those together as operations, liability, and then authority. And by operations, what we're talking about there are really, the day-to-day running of the business and what we need to be aware of from a legal and COVID perspective on that day-to-day grind kind of stuff. The liability seems the most obvious, and we'll talk about liability in really two different arenas there, and those being with employees and with customers and or clients. And then the last area is authority, and that is, from where do we get all of this information for the legal perspective, the laws, the statutes, and the overview of who is promulgating those, who's enforcing those, and how are those being put down the pipe to us. So we can move on to the next one.
Yeah, and I would ask too, that would be more of like your local municipalities and what their regulations are, and that's kind of what you're referring to there on authority. And I guess they're at multiple levels. You got it at the national level, the state level, and then the city level too, right? And they're all different.
Yeah, that's exactly right. And people often ask, and I've had this from several of my clients, is, I see all of this stuff on the national news, but then down here at my local community level, I see something else happening. And how do those work together? Who am I supposed to listen to? And what am I actually supposed to be doing? Because sometimes those are in conflict. So we'll touch on that a bit as well.
Great. Perfect. Thanks. There you go.
Sure. All right. So within that operations bucket, if you will, we're going to really focus on four areas that I think may be most impactful to the entrepreneur and small business owners, and they can see each of those there. And I think what's most important here is that every day there's going to be a little bit of a different challenge and new change. And sort of a focus I would ask folks to look at is be flexible with all of this good stuff and try to anticipate what may be coming up by, keeping up with the news and what's going on in your marketplace. And everybody's is going to be a little bit different. So we're going to go over just briefly cash flow, product service delivery, customer-client relationships, and employee relationships. All right, and this is probably a little bit of old news for folks, but there are a couple new pieces in here that I think are important. And generally, when we're talking about the cash flow, we're talking about making sure that the business can stay afloat. As we know, small businesses' lifeblood is their cash flow. So I thought I'd focus on just two different levels here of where we may be able to get some help on the legal front. And we'll start off with the PPP, the Paycheck Protection Program that was implemented in June. That was, by my understanding, fairly successful with most of my clients who were able to get in the door and do that. Important to note here that these are all small business association programs, and as a result of that, you needed to really have, and still do, a good relationship with your lender who is more than familiar with the SBA rigors and protocols. So that's really important. The Paycheck Protection Program did close as of the 8th of this month. So those funds are no longer available. They've been exhausted. And as we recall, there were actually two separate rounds for that, and I think were successful for most people. There was also put in place right away during this pandemic the EIDL, the Economic Injury Disaster Loan Program. And that was a broad brush kind of program based on the SBA's bigger program, the 504 program, for trying to make sure that businesses were staying afloat that were outside of the Paycheck Protection Program. And these were for just a running of the business, sort of capital costs and everyday costs. That program is now closed, but for their agricultural focus. So if you are in a business where you have some touch on the agribusiness, then there are still funds available for you there. Two things that most people don't know about, but that I think are really important here are the Express Bridge Loan, which again comes under the SBA program. And that is to help folks who are in dire straits that otherwise don't fall in any category, bridge a gap between where they are now and the potential SBA loan that may be coming down the road. And they're up to $25,000 in relief or some help there. Go to the SBA website to find out more about how that may be applicable for your situation. And then finally, there is a debt relief program out there that was even new to me until I did the research for this. But if you are already a business owner under an SBA program of either the Express, which is the 704A program for businesses that need up to $300,000, or the 504, which are businesses that need up to $5 million, or any of the microloans, you can get some kinds of debt relief through the SBA, and I would encourage folks to look to their local banking partners to inquire into those.
Can I ask a quick question on the debt relief?
Please.
Is that particularly for businesses that had loans already, these types of loans you have listed, and now they can maybe get some of that forgiven, or is this a resource that forgives some of the ones that you've outlined earlier under the SBA?
Yeah, these are for folks who already have the regular business course SBA loans, those being the 704As, the 504s, and the microloans are available. So if a business owner has one of those kinds of loans already and are working underneath those strictures and are experiencing some difficulty, there is some debt relief that is available to those folks based through the SBA. Yes.
Good, thanks.
And then in our fair state, there isn't a whole lot of economic help from a loan perspective, but there is a small business grant program that has just arisen, and I think it may be a really good thing. I haven't had any clients ask for or apply for it yet, but unfortunately the window is very small. It's only open until the 31st, so we've got 4 days to do that, and I don't know how quickly those funds will get exhausted, but I did provide a link at the end of the presentation here to investigate that. But suffice it to say, it's for businesses that are less than 50 employees who are organized under Missouri law, and they're really trying to focus on hard-hit industries like the restaurants and the bars and those kinds of public-driven businesses to get them up to $50,000 to help them through their difficult times.
Yeah, like anything in hospitality, probably restaurants, like you mentioned. Retail has taken a really hard hit too. So.
Right, and important to note there is it is focused. That program is focused on those industries, but it is not exclusive to them. So anybody in any business can jump out and apply for it, but they are going to prioritize the dissemination of funds to those businesses that are deemed "quote unquote" hard hit. All right, next we're going to move to the sort of second leg of the operations menu, and that would be the product or service delivery, depending on what kind of business you're in. And looking at issues that come up on a legal front, they're really in more of the supply chain and fulfillment with vendors and outside contractors kind of issues. And those will really arise only under two general concepts of law. The first would be those that are strictly contractual in nature, and the second would be under those that are insurance-driven. With regard to the former, what we are really interested in looking at, and frankly, we don't know a lot of the answers to these questions yet because they have yet to come down the pipe to be litigated, but how do these particular clauses and understandings of contract law work when there may be no ability to deal with these under a COVID restriction? And what I'm trying to get at here is there may be some litigation that comes up where contracts say if there is an act of God or a force majeure clause, which says that things out of control of either party may affect or not affect the contract. So as an example, real simply is, let's say we have some sort of a vendor who's bringing us product, and there's a force majeure clause that says if there is some sort of act of God or difficulty and we can't bring those supplies to you, we're let out of the contract. Well, obviously with COVID, that is going to be a real big issue where a supplier could raise that as a way to not fulfill a contract. How are those going to be treated? We just don't know. Moreover, if we look at disclosures or waivers that are contractual in nature in the same way, how do those happen? If we blow a deadline and don't raise an issue with our supplier, then have we waived the right to bring that up later and say, hey, look, I didn't get my stuff when I wanted to? Or if somebody partially performs under a contract, let's say you were due a whole slate of product and only part of that slate came to you. Does that mean that that contractor is okay to move forward and collect their fee? Are you to pay that fee if you don't get all of what you wanted? And then letters of intent. You know, if we sit down and describe what we're going to do and move forward on a letter of intent basis, and suddenly we can't do that because of COVID, how are those handled? So those are lots of issues that we just don't know about yet, but ones that I think business owners need to be aware of, such that they may be able to, avoid some of those kinds of situations.
And I think that awareness is good for them to know from both perspectives. One is they're trying to deliver and running into problems, and to understand that these variables may work to their benefit. And then on the other side, understanding that some of their vendors and contractors may run into problems, and it could affect the business owner's ability to push back or, like you said, have some sort of financial compensation or something along those lines.
Right. Yeah. And then if you factor in maybe some of those contracts are mission critical. Maybe there's PPE in there that a hospital needs, and those doctors can't work if they don't have that. What happens in that situation? So lots of crazy kind of litigation issues are going to come up. They just haven't yet. But if there's a way that business owners can be apprised that these are issues, maybe we can circumvent proactively to not have them pop up on us. Then with regard to insurance and policies and claims issues, they work on a similar bent in that, we may have a claim for loss of business under a policy, and that may be related to, lack of product or lack of ability to fulfill on a contract. How might that claim function in a COVID environment? We just don't know yet. And frankly, I would be willing to bet that insurance companies are going to be quick to deny those claims under all kinds of policy restrictions. So I think business owners need to be aware that, what policy you purchased, you need to go back and look through and maybe make a call to your carrier and say, hey, look, this is a likelihood for me to deal with. How is this going to function? And maybe talk to somebody on the forefront before that gets to be an issue.
If I can interrupt again, on the insurance policy, not related specifically to the pandemic, but just current events and the civil unrest that just keeps going and going and going and seems to get more radical and destructive. Recently, we were discussing the fact that the destruction, some of the pushback that happens from those that are doing it, saying, well, these businesses have insurance and that is covered, it covers them. My communication back always is that so many small businesses skip this step. Either they don't have insurance because they're trying to make ends meet, or they don't have ample insurance. But also recently was discussing the fact that in the case of civil unrest, sometimes the insurance policies don't cover at all. Is that something that you would have any additional thoughts on?
Absolutely, and you're exactly right. And typically those arise in the property damage arena. And there are lots of escape clauses that insurance companies have in their policies for civil unrest. And those situations which we are seeing on the news every day are directly applicable to that escape clause under those policies. So again, I think what's important here is for the business owner to be proactive. And number one, if they don't have insurance, certainly go forward and try to figure out how that might be best mitigated, because that's going to be hugely important in these days and times. And if they do have a policy, reach out to their carrier and make those inroads and say, hey, look, here's what I may be facing. Am I adequately covered? Is my current policy going to provide me with the coverage that I need? And I think most insurance companies would rather hear from their policyholders on the front end to say, okay, here we go. I'm trying to make sure I'm taking care of things, rather than have to have a big nasty claim come up that may provide fodder for litigation. So again, my advice is just try to be proactive. And then we're looking underneath this prong of products and service delivery at those shutdowns that have happened all over the country, but more specifically here in the St. Louis region with regard to the St. Louis County, St. Louis City, and St. Charles County. How have those been functioning, and where do they come from? And we'll get into a discussion a little later on about where the authority to create those shutdowns comes from. But really what I want to touch on here was the designation as to essential businesses versus non-essential businesses, and really how willy-nilly that kind of standard is. And looking at what happened in St. Louis County, there was really very little explanation given out as to why some businesses were essential and some non-essential. And I don't know that there's any litigation on this yet, but I know there were some businesses that were considered non-essential, which actually probably were, and were forced to shut down and had some really bad economic fallout as a result. Is there any relief that those good folks could get for having been forced to shut down through the court systems. We just don't know that yet either. So the reason for putting that in there would be to tell a business owner, hey, just because you got shut down doesn't mean you have to. You may want to ask some questions, talk to your elected officials, because that is, again, not a hard and fast categorization tool. You may be able to get yourself recategorized.
Let me ask you a question on that one, too, if I can.
Mm-hmm.
It's interesting you bring that up, because how did let's say local governments, did they contact businesses and give them the green light to stay open, or did a business kind of self-designate I'm essential and then have to go out and get a permission for that? What was the process? And like you were giving examples of businesses that were told to shut down that felt like they weren't essential. So how did that happen? Obviously, they probably continued to operations as usual, and then someone reached out to them and told them to shut down?
Yeah, typically that process is driven by the leadership for that governmental authority, whether it be county level or state level or municipal level. But it's usually the elected leadership that are in charge there. And as to how they came about with that list, I don't know that we know. I certainly don't know. And it seemed to be just sort of haphazardly driven. So I don't know really what would be an answer to that question. And just to give you an example, a business like mine, a small law firm, I was considered essential. I don't know how in the world my business is essential to the running of the county, but evidently it was. And I had a client who is a contractor for doing plate glass. And part of his business was deemed essential and part of it was non-essential. And so I got a call from him. He's like, what do I do? And I said, well, you just go out and work and don't worry about it. And he was able to do so. Which brings us to another question is, what is the enforcement mechanism for people who are still working or people who aren't working underneath these forced shutdowns and restrictions? And your other question was, how did this get disseminated? And those came out in those orders that were sent out to the public on various dates back in March. I think it was March 18th or 20th for St. Louis County. And there was a very long, lengthy written order that said, here's what is closing, here's what can stay open, and here's how that's going to happen. And you had to be online to be able to get a copy of that. I don't know that mailed copies or any other word was sent out. So you had to actually jump online on your own and figure out if you fit into those categories or not.
And you were talking about the enforcement. So, I mean, from local
right.
news stories and those businesses that said maybe complied for a while and then said, nope, I'm done with this, I'm back. I mean, some municipalities resorted to arresting them and, pulling them off the street.
Right.
I guess that's the worst case scenario of enforcement.
Right, and there were some quote unquote teeth put into those orders whereby a police authority could arrest folks and charge them with misdemeanor crimes, but outside of the restaurant, bar, arena, I don't know that ever really happened. And it really, how could they enforce something like that? And I think that brings up a good point. In talking about all of these issues, really what we're talking about is trying to have everyone on the same page, working in the same direction to make sure we're all safe. And a lot of this is more common courtesy and common sense driven than it is anything else. And I think that is a standard that the business owner could apply in looking at a lot of these issues is, what is a common sense way to go about it? And that's probably going to be the best way, even given the legal strictures. And what we're focused on in the operations end here is how do we just make sure our customers or our clients are being taken care of underneath our culture within the legal confines that have been erected as a result of COVID. And so really all we're trying to do is, number one, is make sure our customers and clients are safe. And so therefore, if requiring your customers or clients to use a mask or gloves or social distance or hand wash is required, then you can do so. That has always been the law. That is not a new thing. Businesses have always had the ability to restrict service to clients and customers based on that business's needs, wants, and desires. And so that is nothing new. I would say that if you're going to do that and you're going to require some kind of mask or distancing, that a notice would be completely applicable here. Publish that on the front door. Put that on your website. Let that be known so it's not a surprise to a customer or a client coming in the front door or that you're going to go see. And there are particularized languages and statements that work better than others to do that. And I would really encourage the folks out there to contact their attorneys to figure out what would be best in terms of that notice requirement for their businesses. And then also, businesses should have some kind of established COVID-19 policy, which is customer facing, whether that's on a website or disseminated in a newsletter or a letter just saying, we're aware of this, this is the step or steps we are taking to provide the best customer experience for you, and make sure that people have access to that.
When you provide that notice to them, and I've worked with some of our clients to help them develop this, and particularly when they're meeting in person, maybe because they're a service industry, professional service industry, those sorts of things, having that maybe, so I'm curious on your thoughts too, but having that statement that they acknowledge that this is a highly infectious disease or virus, and that the company is stating up front that they're not willing to, or they're not taking liability and responsibility for that they're going to do all of these things and follow the CDC guidelines and those sorts of things, but that there's some responsibility on the other end. Do you see that being helpful in protecting that business by making that statement inside of their policy?
Yeah, absolutely. I think it's always a good idea to reference the CDC guidelines, even though they change daily. What that shows is that you are trying to keep abreast of what is most important at that point in time per a particular authority. And I don't know how much liability protection that will give, but it will at least give a modicum. And with regard to any kind of liability that would arise through a customer contracting COVID and then saying, I got this because I interacted with so-and-so's business or at their brick and mortar, that is going to be yet litigated. But my anticipation is that it's going to be so very, very difficult for that customer or client to show, hey, this is exactly where I contracted that disease or that infection, that there may be a lot of summary judgment on the front end where, the suit may get filed, but it may get thrown out right away. So I don't know if that's a real practical worry from, a dollars and cents standpoint, but I think it's still probably good marketing on the front end and good sales to be able to tell your customer you're trying to take care of them.
Agree.
Yeah, and I think that the real take-home message for protecting customers and clients is there just isn't a lot of guidance out there. We just don't know. And that's because we just don't know a lot about how this virus functions. We don't know how long it really can live on surfaces. We don't know really when it's aerosolized, how far that can go. And frankly, we don't know about how individuals, different individuals, become infected differently. There are just so many questions that are unanswered that science hasn't yet been able to come to a definitive on that we just don't know.
I have to believe, you can tell me if I'm wrong, but there can't be liability to any one individual or entity when it is unknown. And you're talking about like things like how long it lives on the surface and whether it's airborne or aerosol. and wearing of the masks and all those sorts of things, that even the top officials have changed from, I mean, literally flipped completely from don't wear masks, they don't help, to wear a mask, they help. I mean, just as black and white as can be. And then early days, you know, it could live on surfaces for 3 to 4 days. Now it's like, you know, it probably doesn't live on surfaces at all. It might be there, but it's not alive. From a legal perspective, I can't imagine that there could be much liability, really, like you said, until the known is there, and then that's where that line is drawn in the sand to say, okay, now it's known, and this is the standard. Is that somewhat accurate?
Well, liability is going to arise just by having a business. So the idea is just try to mitigate that as much as possible. And to say that you won't get sued is really silly. You get sued for anything. Now, whether or not that's going to affect your insurance, whether or not the plaintiff is going to be successful, whether or not that's going to open up all kinds of other liabilities is not yet known. So to say that there is no liability would be incorrect, but to say that it's probably minimal is more accurate.
Yeah, and I guess I make sure I wasn't saying there isn't liability, because certainly that's why I wanted to get your perspective on all of this, because I realized that there is. But the thought being that in my gut, at the end of the day, I guess to what you coined as a success rate of that plaintiff, right? To say, we don't know, because you just don't know. But my gut just says, how can one be liable when one day they say do this and one day, then, you know, literally a week later they say to do the exact opposite. You can't comply, and you can't do two opposite things at once. So
that's true.
How you could be held liable for that would be hard for me to get my arms around, I guess, in my mind too.
Sure, and that's completely accurate. However, what we're going to see are other kinds of situations where there may be liability, and that may not be underneath the standard kind of description of business and customer. And the example that I would raise right now is the organizers of the Sturgis Motorcycle Rally, who went ahead with their event several weeks ago, and now it has been understood that there were a tremendous number of infections that were derived from that event, and that those people are now out in their own communities carrying those bugs when they went about the event without any kind of restrictions whatsoever and against all guidelines then in place. Situations like that may give rise to liability for those organizers. We are just going to have to see. What it's going to come down to, and unfortunately, is when people start to pass away from this and they can trace it directly back to that event, then we're going to see cases and liability pop up. Those are the kinds of things we need to avoid.
Yeah, absolutely.
And this is probably where most business owners are going to have questions. It's going to be about the relationships that I as business owner have with my employees. And by employees, I'm talking about contractors and agents and anybody with whom you might authorize work to be done. So not necessarily a W-2 employee. But how do I make sure that the business is going to continue running with regard to these people? And I think there are all kinds of liability exposures, which we'll get to in another part of the presentation. But as far as just the operations of the business, I think these bullets on this slide are really most important. And the first is obviously have some sort of open line of communication about what you as a business owner expect from your employee during this difficult time, and sit down and have those conversations in a most earnest fashion up front when that employee comes through the door. Second is a little bit more legalistic, and that is make sure that job descriptions are adequate in terms of describing exactly what that role and responsibility is for that person. And that's important because if that person cannot do those functions according to that description, that may give rise to some kind of claim under either the Rehabilitation Act or the ADA or the EEOC. So it's important that that employee knows exactly what their job is as written down and described to them for their role. Also, what are those essential functions? Same kind of concept, but what am I supposed to be doing as an employee as told to me by my employer? And again, back to the idea that if I can't do those because something happens, and we'll get to this in a little bit, where we'll describe whether a COVID infection can be considered a disability underneath the ADA, it speaks to those issues. And then obviously we want to provide a safe workplace for our employees. So what does that mean? Does that mean regular cleaning? Does that mean disinfecting? Does that mean wearing PPE in the environment? We don't know, and that's going to be a fact-based intensive question for each owner to know about what their business may require. And then we need to talk about keeping records accurately. And really what we're focused on here is any kind of medical record that may be derived as an employee works for an employer needs to be stored, saved, and secured in a different file than the regular employee files. Whether that's electronic or in hard copy, it doesn't matter, but those records need to be updated and made sure that they are separated from all other employee records. And then finally, as it's just good business sense, follow any established protocols and procedures that the business has in place. And we'll talk a little bit about getting into some COVID-specific procedures as we go forward in the presentation. This is probably the biggest question area that business owners are going to have, and what is my exposure given my business and given the current climate? And I chose to break this down into two areas of focus, both from the customer and then from the employee. There are other areas that arise too that could come under contract or could come under property or all kinds of other theories of liability. But I chose to focus here because I think these will be most salient and applicable to people who are small business owners and entrepreneurs. Talk about the customer-focused stuff. And again, what we're referring to here is that we want to keep our customers safe. And that is obviously most readily done by having some kind of environment where the customer knows what's to be expected. And we talked earlier about having that COVID notice put out there. But in addition to that, I think it's important to let employers or business owners, know that they can require any of their customers to either provide their own PPE or provide that for the customer when interacting with the business or the business employees. They can require distancing, they can require hand washing, and they can require customers to follow the protocols that the business has. And as we said earlier, that is ingrained in law long before COVID came about. But every business owner has the right to do that. And as a matter of fact, probably should do that just so that they can make sure that their customers are safe. And then, as always has been the law, the business owner has a right to refuse service to anyone for darn near any reason, including some of the above listed things. So the safety issues are paramount here. As we touched on already, liability may not necessarily flow from an incident where someone may be infected in the business or with contact with one of your employees, but I just don't know that now is the time and a place to make those risky kinds of calls in terms of running your business.
Let me ask you a question about the right to refuse on service. If there is, and I've seen some buzz about wearing the mask, whether you've got a health issue, let's say claustrophobia, so more of a psychological, emotional issue, or maybe even a religious concern about wearing it. Can a business then, under the Civil Rights Act, refuse to still serve you, or you've got a little bit of an out in that regard? Are those legitimate in this situation?
That's a good question. I believe with regard to customers and clients, that is still fairly ironclad in terms of the business owner's ability to say no. Now, it can't be done so on the prima facie grounds that they're denying service based on some sort of protected class issue. So if that person is a minority person and the business owner is using the requirement for PPE and that person's lack of compliance as a cover for what otherwise would be a discriminatory issue, then they cannot. But I just don't see how that's going to come about from a practical end. So the business owner, I would say, has a right to refuse to anybody. And if that gets to be an issue or if that escalates into a problem, then my advice to that business owner is contact the police immediately. Get them there, have them make the record, have them de-escalate the problem, and take that customer off the premises. All right, and then with regard to sort of tangential issues, I know businesses are looking to expand their offerings and their abilities to serve the customers by trying to offer different avenues for those products and services, whether they be online or delivery or otherwise. But what I wanted to bring up here is the idea that in extending that ability of the business to conduct their business outside of their normal methodologies will open up other avenues of liability as well. And the specific one there is the delivery. You know, let's say we are a small, corner deli, and we didn't have a delivery service before, but now we're going to realize, oh my gosh, I've got to do that to stay afloat, and we offer that delivery service. We've opened ourselves up to all kinds of liability for that delivery person out there, navigating the streets and getting that product to the customer, and then the customer-facing end of things. So there are all kinds of new liabilities that come up there, and I would caution business owners to think through those before they implement some of these other strategies.
Liabilities beyond just the pandemic, where you're like the
Exactly.
delivery, you've got the driving, and you've got there's different insurance coverage just for delivery drivers in a restaurant situation, and that may be different.
Absolutely.
I'm sure that's the same if I'm delivering product that's been bought from my store in a retail environment, even if, I elected to have that service involved. So that's what you're referring to too, over and above just the pandemic, right?
Absolutely. It's just the thought process that the business owner needs to go into to recognize that, yes, you may be creating another revenue stream, but realize you're also opening up other avenues of liability that go along with that new revenue stream. And just to make sure that the business owner does the proper cost-benefit analysis in deciding whether or not that new revenue stream may be worth it. Good point. All right, now, again, as with our previous category, in terms of the liability, the employee liability is probably what most business owners really need to be aware of. And as a matter of fact, there is plenty of guidance on this particular issue at the websites for the EEOC and for OSHA, and there are even some state websites. And I've included them at the end, and they're actually very good in that they will go through and look at all kinds of different scenarios and typical questions and provide well thought out, well-reasoned answers. So what I've provided here is just sort of a highlight overview of those kinds of questions, and I'm not going to go into most of them, but what I'm going to say is I've broken them down into what an employer or an employee may or may not do, and then what they should and should not do. So a lot of the questions surround, keeping my employees safe from themselves, from their families, and then from passing that along at the job site. So what can I ask my employees to do given the HIPAA requirements and given what kinds of other issues may arise with dissemination of a disease like this. So the most common questions are about when my employee comes to work, what can I require them to do, especially in the HIPAA environment. And so you can require them to wear the PPE, socially distance, but you can also require them to pass through a temperature screen. And that is not a no-no anymore. You can also ask them if they've had any kind of symptoms that may be COVID-related to provide a fitness for duty certificate or a physician letter saying that they are in fact healthy and capable of doing the work that's required of them. But what's important here to note is that you as the employer have to have some kind of knowledge that there was a virus-like symptom that employee either had or has currently. If that is the case, then you may ask them about all kinds of other issues with regard to where they've been, who they've been around, and why they've been absent. But absent that finding, you can't ask them those questions. And as of this point in time, that particular standard, whether they've had virus-like symptoms, hasn't been really fleshed out. So we really don't know what that looks like. So my advice to employers would be to say, if that person has any kind of fever, if they have any body aches or any kind of respiratory issues, that is probably a signal that you can ask these questions.
Is that something they can ask now just because of the pandemic situation, or is that something employers have always been able to ask?
No, that is directly COVID related. Typically in the past, the employer had no ability to ask any kind of health-related questions of an individual unless that individual broached it first. So those questions were off limits.
And and when the pandemic is over, would that go back to the way it was, or do you anticipate this will be a new norm?
Yeah, that is an excellent question. And my advice would be consider this to be the new norm and move forward with it. Now, it may not be, but it's a lot easier to pull back than it is to implement. So yeah. And there may be lots and lots of other questions there because this is also very fact-intensive. So different situations call for different treatments. Different businesses may be required to work differently.
Absolutely.
Any other questions that you might have on that front?
I do on the second section here, but I don't think you've jumped into that yet on what the employers cannot do. I do have a question on the vaccinations because I have heard some buzz that employers are anticipating, they're letting their workforce work remotely in a professional environment, so to speak, or not so to, what I'm saying. And then they're saying, okay, we think that this vaccine, they're saying now it'll be out by the end of the year, and they're anticipating that they're going to require the vaccination to come back to work. I've heard some buzz about that, and you're saying here that they cannot do that. So I'm intrigued. Yeah.
And as of right now, the only advice that's out there is on vaccinations of a traditional flu variety. So the traditional seasonal flu vaccine, which is out every fall here in North America, you cannot compel your employees to get that. However, with regard to the COVID stuff, we just don't know yet because we don't know, number one, if we're going to have any kind of viable vaccination. And even if we do, we don't know how that may be efficacious across a large swath of the population, nor do we know, frankly, if it's even going to be something safe for folks because everything's been so quickly pushed through. So I would say in forward looking as to any sort of COVID vaccination, the same will also be true. I don't know that an employer is going to be able to compel anyone to get that. I would guess even in a first line responder healthcare situation, they can't compel that either. Furthermore, there are religious exceptions that are replete in current law that keep people from having to have those kinds of vaccinations as well. So I just don't see that coming. Now, whether it would be good advice or not, may be a different story. But the compulsion certainly won't happen for flu bugs, and I would guess even not happen for COVID bugs once they come down the road.
All right. Thank you.
Sure. Any other questions on that stuff?
Not right now, no. This good
Okay.
info, though. Very good info.
Okay. And this is similar kind of concepts and thoughts, but this is more of what employees really should be doing, employers rather should be doing, and that is what you see in the top bullet there. Go ahead and establish those cleaning and sanitizing protocols. And I don't know that there's a lot of guidance there. I think there should just be a written policy in place talking about in my work environment, this is what I'm going to do as the owner/employer to make sure that we are cleaning and sanitizing as best we can, and make sure that the employees do see that and know that they are to be protected by it and abide by it. The second bullet there is talking about a COVID-19 control plan, and that is a very specific document that is being derived almost every day as we speak. And that is a very specific way to tell your employees if we do have an outbreak, or if we suspect there's an outbreak, or even if we think we want to protect against one, here is a written plan on how we will address that. And those can be tricky to write because they are very business specific, but I think very necessary. And the idea there is to have that either as a part of a handbook or a separate and distinct document which the employer and employee will go over and the employee will sign off on to ensure that there is good communication about this COVID issue specifically. And I would encourage any business owner or entrepreneur who may want to do this to contact an attorney and develop one of those kinds of control plans. Similarly, I think it's going to be really important to post what we call compliance attestation posters, and they are just exactly as it sounds. Just something that says employer and employee have agreed on the following kinds of protocols and have everybody sign off on that as well. The difference here is that is an outward-facing document which is posted in the business for those employees to see, rather than a handbook or a control plan, which is typically kept by the employer and employee on their own. And the last one is probably the most important. And what we're talking about here is specifically underneath the Americans with Disabilities Act, if there is a person who is treated as being disabled under that act, and they have COVID, or if COVID is deemed to be a disability, then whatever is the accommodation being made for that person should be the same for all of those people who are similarly situated. And to treat them differently gives rise to all kinds of liabilities underneath that particular law. So bottom line for employers is, and business owners is, treat everybody who asks for an accommodation exactly the same. I know there'll be lots of questions there too. Danette, do you have anything on that front?
Yeah, I do. So what you're saying is that somebody, wants to work remotely because they have concerns for, let's say they have a compromised immune system or someone in their family does, and you allow them to do that, and then someone else wants to work remotely. Do they have to have those same concerns in order for you to grant them that? Or do you have, because of this clause or this bullet point, or do I have to say yes to anyone that just is a little bit concerned about their health and wants to work remotely?
Yeah, that's only underneath the accommodation prong of the ADA. And in order for an employee to raise that as an issue, that employee must be considered, quote unquote, disabled within the confines of the ADA. And there are very specific definitions about that. We won't get into the weeds on that here, but to say that if you have COVID and an active infection, you will likely not be treated as having a disability for ADA purposes. However, if you do have other issues that may not be considered a disability or could be considered disability under the ADA, for which you haven't previously asked for accommodation, If you combine those two with a COVID infection, it may in fact be a disability under the ADA. And the example that I've seen raised as an illustration is, let's say I have a worker who is working for me and never had talked to me about any kind of disability before. Well, it turns out that they have some sort of mental health issue that they're having treated on their own and without any impact on their work environment. Let's say they contract COVID, and that COVID exacerbates their mental health condition, where now they may have an issue with their work. That person may be, in fact, treated now under the ADA as a disabled person, which gives rise to the accommodations problem. Does that make any sense at all?
Yeah, I think so. So the question I was asking isn't related probably to the ADA as much as just if I accommodate and make exceptions for one employee, and you can address that separately. I'm not trying to cloudy it and make this more complicated under this particular
That's a great question.
Yeah, what's my responsibilities, I guess, as an employer in that regard?
Yeah, in terms of legalities, you can treat them any differently, however you want. What you have to be careful of, though, is there are certain quote-unquote hidden disabilities, the example of which I just gave of one, where a person may have a mental health issue, which isn't affecting their work, but suddenly does if they contract COVID, that does become an issue that the employer is unaware of all of a sudden, and then they're in a pickle. So from a practical standpoint, I would suggest that any kind of generalized accommodation, and I wouldn't call it an accommodation here because that is a term of art specifically used under the ADA. But I would say if you change the way that a worker does his or her job such that they can work from home or that they have a flexible schedule or whatever changes are necessary, that be as common and across the board as possible, not only to keep harmony amongst the workforce, but also so that you avoid the pitfall of any unseen or unknown potential ADA claims.
Got it. You haven't jumped into the do not yet, but that seems to make a lot of sense. You're not firing people just because they have the virus. Okay. Do you have to give them the 2 weeks? I know originally some of the federal requirements were saying, hey, and some of the financial compensation that was rolled out from the federal government through the stimulus packages and things said, hey, you can get paid for those 2 weeks if you have to care for someone, if you are sick and at home. So part of my thought process has been, how long does that go on? Because, some people got sick in March and April. Now we're going into September. What if I get sick in November or December? And that's not exactly what you've got bulleted pointed here, but maybe if those federal programs are still there, does the employer have to still grant you that time if a spouse or a child is sick that I need to care for? How does that work?
Yeah, that's a great question. And you are correct in your assumptions that 2 weeks is still required. However, it's going to depend on the business and whether they fall underneath the FMLA or not. And there are further complications there. And you've anticipated a question that we'll get to down the road, but I'll go ahead and address it here. If that business is deemed to have been covered by the FMLA, then there are up to 12 weeks of leave that are available to that employee without recrimination by the employer. And we'll get to that rubric here in a bit, but just to answer the question, if the business falls within the ambit of the FMLA, then there is. If they don't, there likely is not. However, there has been an extension passed by Congress at the federal level to extend the FMLA to businesses that are less than 50 people and for a 30-day window. So it opens up a larger window of employees to have some kind of 12-week leave to do those very things, but it restricts it only to having a need to care for a daughter or a son because of some sort of closure either at their school or daycare or otherwise, and only if that son or daughter is under 18. So very, very narrowly tailored underneath the extension. But typically, what I would tell an employer here is give those people whatever time they need off. And if you suspect that they're malingering or doing something odd, you have every right to ask for them to bring in some sort of certificate of duty to work or some sort of physician's letter saying they're going to need this amount of time off.
And FMLA standing for the Family Medical Leave Act, correct?
That is correct. That is correct.
And the 12 weeks that you're referring to, and that's really interesting too, that it's under 50 employees, because that's kind of what the FMLA, that's the benchmark, is 50 employees or more. The business is required to adhere to these requirements and these benefits, let's call them. But you're saying now, because of this pandemic, anybody under 50, the federal government then is saying they're requiring smaller companies to provide, let's say, the 12 weeks that you talked about. That's 12 weeks where they don't lose their job, but they're not being paid by the employer.
That's correct.
Right? Okay.
Yeah, I just moved up a couple slides so I can make sure I get this right. So the FMLA only applies, the larger act that's been in place for multiple years only applies to those businesses that have 50 or more employees, and that employee has been employed there for 12 months consistently and has done 1,250 hours of service work for that business. And if there are multiple sites, then that business has to have 50 or more people within 75 miles of the locus of that business. Then the FMLA applies. However, the extension digresses a bit in terms of those requirements.
The bullet says under 500 employees. Is that a typo?
No, that's how the language of the Expansion Act is written. And it follows in the line of the CARES Act, which was talking about the threshold for services to be under 500 employees. So it borrowed that same language, which is different than the language of the larger act. But essentially it says any small business can apply for the expansion, even if they don't have 50 or more. So a business of 1 to 2 people could apply under, or that employee of that business could apply for FMLA Expansion Act coverage to get in and get those 12 weeks of leave. And they only have to prove up they've been at that business for 30 days. That employee does. So there's no more 12 months required. So it's quite a bit different.
Right. Yeah, quite a bit.
And essentially what are the takeaways here are, number one, existing law that has always been in place with regard to any business owner is still in place and will still apply. Nothing has been changed in that regard. We'll also talk about sources of authority, and that's where we get into, where am I to look for guidance on what I can and can't do as a business owner, whether it's from the federal, state, or otherwise authority. And then finally, the last bullet will be essentially those websites that I've included at the tail end here, which are elucidated earlier in the presentation. And we'll talk about the top two bullets. The first of which I can't stress enough. Just because we're in COVID times does not mean that anything out there in terms of how a business owner has run their business from a legal perspective has changed. Nothing has changed. Nothing has suspended. Nothing has been abrogated. All we've done is extend a few things. So that's really important to notice. And then second, the reason that we include the Americans with Disabilities Act here is because of this idea that COVID-19 could be, in fact, considered a disability under that law. And as a general principle, it will likely not be. So any employer who finds out that an employee has COVID doesn't necessarily need to go into all of this analysis and legal work, but they do need to make certain that there isn't an underlying comorbidity which may give rise to a disability, like we talked about earlier with that hypothetical worker who had some kind of mental illness but was managing it, who gets infected and then has an exacerbation. That may in fact be considered a disability, which would require a reasonable accommodation for that employer. And again, this only kicks in if that employer employs more than 15 people. So for the vast majority of our folks who are small business owners, the ADA doesn't even apply.
All right.
So once we talk about, what are those reasonable accommodations, it is well within the law that working from home is a reasonable accommodation. And there are a whole boatload of other accommodations that may be, in fact, good choices underneath this kind of need for a worker. And I would suggest that if this ever comes up, that employer contact an attorney as quickly as possible to make sure that's followed through with, because this is a very tricky area of the law, and you can really get yourself hung out to dry if you're an employer that doesn't follow it correctly. All righty, I think we covered the FMLA stuff pretty well there. What I would say, just as a brief wrap-up on this section, is these aren't exhaustive. None of this that I presented today is exhaustive whatsoever. It's just kind of a heads up what to look forward to. And the bottom line, I would say, for most business owners as a takeaway is, when in doubt, contact an attorney. When in doubt, do that. What I really want to point out here is there are a number of areas which a business owner needs to be aware, from which authority does derive, and from the top to bottom, federal, state, county, municipal. Well, what's important here to know is that the locality that is the smallest will often control. So municipality law will trump county law, will trump state law, will trump federal law for the majority of times. So if a business owner is confused about what they need to be doing under certain kinds of restrictions, look to the local municipality first, then look to the county second, and go up the scale from the bottom. That's what I would suggest.
Bottom up
they do.
is the authority level.
Yeah, and as always, if there are questions, contact your attorney. All right, and then the last slide, Danette, is simply the reliable information. And to the extent that it's reliable is probably, I don't know, but that's the best we've got, so that's what we've got to work with. So just try to be flexible, just try to be as proactive as possible, and work with what you have at the current time. That'll do it. Questions?
I was just going to ask, too, how people that could get a hold of you if they've got more questions or want your help in some area, but this last slide obviously gives that your phone number and email address and website. So this was very, very comprehensive, very interesting, and opened up a lot of questions that I hadn't even thought of. I think the majority of what I was wanting to address, you just kind of covered in one bullet point, which was kind of what do we need to do to kind of protect ourselves and be compliant and proactive in working with customers first and foremost, and then employees as well. But, this is great information, so I appreciate your time. Thank you, Eric.
Hey, thanks for watching the video. If you'd like to get more information, go ahead and text GROW, or the word grow, to the number right here, and we will send you our Grow Like a Pro report. Hey, don't forget to subscribe. Click the bell right here so that you can get more tips and tricks and insider secrets on how to grow your company consistently, predictably, and profitably. Thanks.